Let's talk about what easements do. Easements create a right or a kind of interest in real property or land. That can be a right to prevent changes to an existing structure or landscape, or a right to create affirmative duties. Easements create a legal agreement that's very much like a contract between the person that owns land or property that's being preserved or conserved and some entity, like a government agency, a land trust, or a preservation organization. That legal agreement restricts what it is that the landowner is allowed to do with their property and gives the easement holder ownership of the right of development. What landowners like about conservation easements is that they still own the property. They've only given away limited rights. Even after the easement has been given on a piece of land, the owner can still sell it and pass it on to their heirs, just with this restriction placed on it. Once you donate an easement, you can't just retrieve it or take it back. It's a contract, and these easements generally last in perpetuity. Also, the easement holder is responsible for enforcing the terms of the easement, although it is possible to appoint a third party to make sure that everything is going according to plan. Conservation easements prohibit certain activities and uses of property that have a dollar value. For example, the right to develop farmland and turn it into a commercial development, or the right to alter the exterior of a historic building. You can also require that a property be used for a certain purpose. Again, that a farm remains a farm, or that a wetland is maintained to protect a certain species. These agreements can be drafted as restrictively or as loosely as the two parties can agree on. They can be written, for example, to allow limited development, or to allow the construction of facilities that promote a non-prohibited use, like building agricultural buildings on preserved farmland. Easements don't just pop up out of nowhere. There are laws at the state level that address what it is the easements can accomplish and how they should be executed. Many of these laws are based on the Uniform Conservation Easement Act, or the UCEA. Again, this is a model act that states have looked to in order to create their own enabling laws for the establishment of state conservation easement programs. The act was created and recommended for use by the National Conference of Commissioners on Uniform State Laws. This is a non-governmental body that drafts a lot of different forms of uniform laws for use by state and local governments. Now, the UCEA enables the attachment of obligations or restrictions to real property to protect historic sites and natural resources. And this is the purpose of most easement laws. Now, the UCEA is not a law, it's a model. All 50 states have adopted some form of conservation easement law. Some, but not all, have essentially just adopted the Uniform Conservation Easement Act. Conservation easement enabling legislation typically covers these topics. They create a right to limit development or to require actions like maintenance. They define the purpose of easements. They define the restrictions and obligations that can be detailed in these agreements. These laws also define who it is that's eligible to hold an easement, how long restrictions will last, how the document can be changed or ended, what happens when the easement holder buys the property, what happens when the property is subject to eminent domain, and who exactly is allowed to enforce the terms of the easement. Let's consider rights. These laws establish that easements transfer an actual property right. Take a look at some of the language from the state laws and the Uniform Conservation Easement Act. They all create what's called a non-possessory interest in real property. The Uniform Conservation Easement Act, as well as state laws, also define what it is that easements can be used to protect. Generally, these are natural or historic resources, natural scenic or open space values, agricultural, forest, and recreational uses, natural resources, air and water quality, and heritage resources. Now, there are additional resources that are protected under specific state laws that aren't covered by the UCEA, resources that are specific to or important to certain states. For example, Alabama and South Dakota each have specific provisions for the protection of forest resources or paleontological resources. Nebraska, Mississippi, and Montana all have specific portions of their law that protect wildlife habitats using easements. Here's what the Kentucky law names as the purpose of easements. In Kentucky, easements can be used to protect places with natural, scenic, or open space values for agricultural, forest, recreational, or open space use, as well as protecting natural resources, maintaining or enhancing air or water quality, or preserving the historical, architectural, archaeological, or cultural aspects. You can see that the state has essentially adopted the provisions of the UCEA. One of the more helpful resources in researching conservation easements, or becoming familiar with them, is the National Conservation Easement Database. This database compiles records from land trusts and public agencies throughout the United States. It's a voluntary database, though, so it's not an exhaustive list, but it is very inclusive, and it's also helpful in giving you a sense of what it is that's considered important on a state-by-state basis, and who it is on a state-by-state basis that's holding conservation easements. So it's a great place to start. I want you to take a few minutes to look around the National Conservation Easement Database to see how it is that the different states stack up. Then take a few minutes to answer the questions that follow.